Hear ye, Chief Justice and Justices of the Supreme Court of the State of Michigan. All persons having business with the Honorable Court are admonished to draw nigh and give attention if the court is not sitting. God save the United States, the State of Michigan, and this Honorable Court. Welcome to the afternoon session. We'll call the first case, Harrell versus Titan.
Good afternoon, Chief Justice, Chief Justices. Ron Sanction on behalf of Appellant Titan Insurance Company. It's my pleasure to be here before the court today on an issue that we deem to be of prime importance to the motoring public in the state of Michigan, namely the rash of uninsured motor vehicles that are being operated on the highways of the state and the Michigan Assigned Claims Plan, which we are forced to fund, paying for no-fault benefits incurred by frequent users of these uninsured motor vehicles. This case requires proper interpretation of the phrase, or the term owner as used in the No-Fault Act, specifically MCL 500.31012KI, which defines the term owner as those individuals having the use of a motor vehicle for a period of time greater than 30 days. What does the phrase having the use mean? It does not mean having the proprietary use. It does not mean having the possessory use. It does not mean having the exclusive use. It does not mean having the regular use. It does not mean having the continuous use. I respectfully submit to the court that all those phrases are judicial engraftments onto the otherwise clear and unambiguous statutory text, having the use. The No-Fault Act was amended back in 1988 in Public Act 126 to add the definition of the term owner. Prior to that, the courts had to rely on the definition of the term owner that was presented in the Motor Vehicle Code, MCL 257.37. And in a case I referenced in our application, Laskowski versus State Farm, the Court of Appeals did just that. They borrowed the definition of the term owner, having the exclusive use from the Motor Vehicle Code, and used it for purposes of interpreting the No-Fault Act. 1988, the legislature amended the No-Fault Act and at the same time revised the definition of the term owner in the Motor Vehicle Code. That was 1988 Public Act.
Counsel, good
25.
afternoon. I just have a question, though. I mean, you're focusing on the word use, but what about the term control? In this situation, did the individual in question have really control over the vehicle? She wasn't able to use it without permission. It was unknown if she was going to have such permission. So at the end of the day, how can you say that someone is in control of an object or control of a vehicle if they don't have the ability to access it whenever they wish to access it? Am I an owner if I can't access my own property?
Because the statute doesn't say having the control of a motor vehicle for more than 30 days, it simply says having the use of. And again, contrast that with the phrase exclusive use. That is found in the Motor Vehicle Code. The Motor Vehicle Code definition of exclusive use was laid alongside the No-Fault Act's definition of having the use, because both acts were tie-barred, Public Act 125 and Public Act 126. Having the exclusive use denotes control. Having the use of was obviously intended to broaden the scope of those individuals beyond those who may have control of the vehicle.
But aren't I really borrowing at that point? I don't understand. I mean, I'm just confused with your argument. Because ultimately, how do I have use of something if I don't have control over it?
Because you turn to the dictionary definition of the noun phrase, the noun word, use.
But do you really think the legislature meant that I can have continual use if I mean, an owner that doesn't have the ability to continually use their vehicle would actually be an owner? I mean, does that have a sensible logic to you?
That's what the legislature intended by using the phrase having the use, not having the exclusive use, or having the continuous use, or having the proprietary use. Again, that's not what the legislature said.
Let's look at it. I mean, the phrases, a person renting a motor vehicle or having the use of a motor vehicle under lease or otherwise.
Correct.
Contextually,
what meaning do we infer from the renting, the leasing? How do those factor into how we give meaning to, I admit, use doesn't require ownership, doesn't require title, it means you get to use it. But is there anything about these other words that gives some additional coloration to what use means?
I would respectfully submit that it does not, because when the legislature used the term under lease or otherwise, they intended to go beyond renting, to go beyond leasing, to use or otherwise. And to certain...
But or otherwise is kind of like a list or anything similar, right?
Well,
Isn't that noscitur associus kind of territory?
or if they use the phrase and similar things, but I think when they use the term otherwise, I interpret the term otherwise as being a little broader than just limiting it to renting or leasing situations.
Okay.
And when you couple that with the fact that the No Fault Act amendment was added in 1988 alongside the Motor Vehicle Code amendment, which reworded the Motor Vehicle Code definition of the term owner and used the phrase exclusive use, I think that intends to denote a broader reading, a broader interpretation of the phrase having the use, and you turn to the dictionary definitions of the term having the use.
But how can I own something if I don't have control over when I use it?
Because the legislature says just having the use of the vehicle is sufficient.
But then how, if you go to the word owner, how can you own something if you can't control when you use it? I'm just going, if you're trying to do this strictly, I'm trying to now get you to define to me what owner is. How can you own something if
legislature
you
has
have to
defined
ask
the term
permission
owner.
to use your own car?
The legislature has defined the term owner for you. And under well-established case law, where the legislature provides the definition, this court is bound to use that definition regardless of what common sense, as you seem to indicate, or regardless of what other usage or other definitions of the term owner may be out there. They gave us this definition to work with, having the use, and in this case, can it really be argued that Tamika Harrell did not have the use of this vehicle for a period of time greater than 30 days? In 2.5 years, she gets 7 traffic tickets.
Let me interpose a question. You think about different ways or concepts of ownership. Obviously, a title owner, the title or legal owner, that's one way to be an owner
Correct.
of something. The statute speaks to also having the use under a lease. So someone has a right to use something under a lease, under that concept of a rental. That still qualifies. In Twitchell, we called this having the use as we turned the phrase into the right to use.
That's correct.
You agree with that formulation?
Yes.
So if you're not the title owner and you don't have a lease, what are the ways that you can show that someone otherwise has a right to use something? How would you show that?
Sure, by virtue of the marital relationship, by use,
Well, but just the relationship.
or family members. One way to do this.
But just the relationship itself's not enough, right? There has to be some type of actual use of the vehicle. Is that?
Well, if you take a look at the Motor Vehicle Code definition in the Owner's Liability Act, for example, it says the following individuals are presumed to be operating the vehicle with the knowledge and consent of the titled owner: spouses, family members.
But we don't
That's
have
MCL.
that. We don't have that here, right?
Well, you can read the Motor Vehicle Code in pari materia with the No Fault Act if you need to. And again, this was referenced in that unpublished Court of Appeals decision that I attached in the application that expounds on what this court enunciated in Twitchell. That's the Vukanaj versus Amerisher case. In Vukanaj, the wife had sporadic use of the vehicle, but she was nonetheless found by the Court of Appeals to be a statutory or constructive owner, relying on this court's decision in Twitchell versus MIC General, because by virtue of the marital relationship, she had a right to use that vehicle even if the actual use was spotty and exceptional.
Well, what if, for example, you are blessed to have teenagers in your household,
Which I do. I have.
and you absolutely forbid them from using the vehicle? It's there all the time, as unfortunately children are too, and one of them goes out against your explicit wishes and has what teenagers do, has an accident. Does that make that particular usurpation a use of a motor vehicle for a period that is greater than 30 days?
I would submit no, and the fact is
Why?
that's why? Because they have no right to use the vehicle. They've been told you have no right to use the vehicle. This court addressed that situation, for example, in Spectrum Health versus Farm Bureau, Progressive versus DeYoung. That does not give rise to a right to use because they've been told you have no right to use the vehicle.
Now, let's say that I'm less draconian a father, and I say, okay, I will permit you periodically, if you can justify your need for the car and you bring home eggs, and those conditions are met, my child goes out, has the accident. Has he then been did he use the vehicle in the manner contemplated here?
Yes. In that situation, I would submit to the court that because that child has a right to use the vehicle per Twitchell, and they have the right to use that vehicle for a period of time greater than 30 days, as contemplated in Twitchell.
And how do I get to the 30 days? Because the conditions can be met at any point for 30 days or more?
Correct. And again,
So to restate the question, if you have a situation of serial permitted use for a period of 30 days, that satisfies the owner provision.
by applying the dictionary definition of the noun word use, I submit the answer is yes. The act of using or putting to a purpose, the condition or fact of being used, the act or practicing of employing something. Those are all dictionary definitions of the noun form use, as in having the use.
We have having the use.
We have
Which I assume is why, we don't have use in isolation in this statute. The phrase is having the use, which I assume is how we got to say that the right to use the vehicle, not the actual use, is the critical inquiry.
Well, for
Correct.
example, Webster's two New College Dictionary
No,
defines
I don't dispute what the dictionary says use means. I'm not, like, I'm with
having
you.
the
I
use.
get it. I'm saying that the statute doesn't say use in isolation. It says having the use.
Right.
And I presume that's why this court, I wasn't on it, I don't really know.
the act of
Just-
using or putting to a purpose the use of a car.
Okay, but
Is-
again, I'm trying to figure out the difference between draconian Dad Bob, who says never, and round-heel Bob Dad, that says prove it, and now do it sometimes. The first you say no, the second time you say, well, yeah, because you will allow this periodically on the establishment of the preconditions I said.
Because the statute, again, doesn't give us anything more other than having the use. And
So in that
So-
sense, my child has the use when I permit it.
when you permit it.
What if I have an RV and my neighbor wants to borrow my RV to go camping on a 3-day weekend? And it turns out they kind of know I never use my camper on Memorial Day weekend, and that's 3 days, and the life of a camper is 10 years. Are they somebody having the use of my camper for more than 30 days? Because, 3-day weekend times 10? Like, the first time I loan it to them, well, here you go, here's my camper, it's Memorial Day weekend, but they know I'm never going to use it on Memorial Day weekend. Are they a person having the use of my camper for a
If you-
period more than 30 days?
Well, so you give it to them over Memorial Day weekend and they keep it all summer long?
No, they just get it for 3 days every year for 10 years.
Serial.
No,
Why not?
because the 30-day provision appears in other provisions in the No Fault Act. For example, in Section 3102, the legislature has indicated that out-of-state residents who are traveling in the state of Michigan for more than 30 days in a calendar year have to register their vehicle or insure the vehicles for Michigan no fault
So
benefits.
now
So it's like a 30-day per
Calendar.
calendar year.
Oh, 30 days in any calendar year.
Well, that's what Section 3102,
Okay.
which again deals with out-of-state residents traveling in the state of Michigan.
So that's what you
More
think
than
this
30
means,
days.
30 days in any calendar year.
It puts reasonable context on it because it appears in other provisions of the No Fault Act.
3102 comes after 3101, where
Yeah.
that restriction wasn't put in there.
So everything, it's,
Well,
parts is parts, it's
parts
all
is
in
right.
there.
Right, well, parts is parts. And again, even in the motor vehicle code, it says having the exclusive use of a vehicle for more than 30 days. And That doesn't seem to have caused a problem in years past. The reason it caused a problem in this case is because of the sheer amount of uninsured motor vehicles that are out there, and the Michigan Assigned Claims Plan, of which Titan is a participating provider, funded by you and I, picking up the benefits for people like Tamika Harrell, who undoubtedly, unquestionably in our opinion, have the use of that vehicle for more than 30 days as the wife of the spouse, wife of the vehicle owner.
If it said 30 consecutive days, as it does in subsection 2, would you make any distinction, or do you find it indistinguishable that the right to use might be in a single chunk of time of 30 or more days, as opposed to being, say, 10 chunks in which you have to ask permission every 2 or 3 days and secure the authority of the owner to use it?
I think you're referring to the new amendment to the No Fault Act dealing with statutory ownership of motorcycles, which does reference.
I understand it's a different
consecutive days.
context, but
Okay.
nonetheless, you've got consecutive days.
Yeah,
Consecutive days there.
The fact that the consecutive days is missing out of the motor vehicle code, or out of the No Fault Act's definition of ownership of motor vehicles, takes it outside that scope. If the legislature wanted to meet 30 consecutive days, it could have amended the motor vehicle code definition, or the motor vehicle ownership provision, to indicate having the use of the motor vehicle for more than 30 consecutive days, when it added the motorcycle constructive ownership provision, which it did not. So there's a difference between how motorcycles are treated and how motor vehicles are treated.
Okay, but I still have my chunk question. Even if it is 30 consecutive days, does that mean that there has to be a single grant? The word is period in the singular. Does that mean that the grant, the conferral of authority, has to be for the entirety of that period, or can it be done sequentially? That's what the latter is what seems to have occurred here. There was authority to go to the store for some eggs or to go down the street for some other purpose, but every time that authority was sought again, it had to be conferred again by the owner.
Well, this case is different because it's far more extensive than that.
I'm not
The-
asking
the
about
actual
the
use.
extent of the authority. I'm simply asking, does 30 consecutive days refer to something that occurs in one chunk, that is in a single grant of authority, or does it,
Yes.
can it encompass something that occurs
Serial.
on the basis of a dozen requests for
30 consecutive days means 30 consecutive days. That's a single grant, and if you take back
a single
vehicle.
grant of authority?
take it back after 20 days, that's going to run out there. But we're not dealing with 30 consecutive days, because that's not what the statute says. It says it with motorcycles. New amendment, effective January 2015, does not apply to motor vehicles, which still retains the old definition, having the use of a motor vehicle for a period of time greater than 30 days.
Thank you. Your
Thank you.
Good afternoon, Your Honors. My name is Mark Grail. I'm appearing on behalf of the plaintiff, Tamika Harrell, the appellee. Justice Young, if you indulge me just for a moment here, taking your hypothetical one step further. Let's say we have a college student that's attending college out in California, and he comes home for the summer, and he lives with his parents, who have a car, not two, just one car. And the parents say, yes, you can occasionally use this car, you know, to go up to Walmart or whatever throughout the course of the summer. And let's say the insurance has lapsed on this car, and this college student doesn't know that. He's not responsible for paying it. He doesn't pay it, put gas in it. He doesn't pay for any maintenance. He doesn't do anything with the car other than his parents said, you can use the car, you know, if you have our permission over the course of the summer. And it's uninsured. And he gets in a car accident. If you take Titan's position to its logical conclusion, he would then be considered to be the owner of this motor vehicle. And he would, if that was the determination, he would then be cut out from any Michigan no-fault insurance benefits. Now let's take the same car, and his sister's in the car at that time. She's a passenger. Since she's not driving the car, she could then seek Michigan no-fault benefits from the assigned claims facility. But her brother could not because of some some argument that he's the owner of this motor vehicle. And that doesn't really seem fundamentally fair, nor does it seem to be like it should be in line with the Michigan No Fault Act. And I just thought, I'll just throw that out. What we have here is,
Well, let me just, in the college situation, it seems to me that is a grant of authority for use for a summer, which is more.
if he has to ask for permission every single time he wants to use that motor vehicle. If he says, Mom, I want to go up to the Walmart, and she has the decision-making power to say the yay or nay.
That's what we're trying to figure out, whether use has to be conditioned on something other than actual use, or the act of using the car, or it has to be permitted, other than, generally speaking, you're authorized when you're authorized to use it. Why is serial permitted use over a period of 30 days transform the user into a covered person under the No Fault Act?
Well, it would be for the sister if she was in the car, but
there are asymmetries all over the place. I mean, but this apparently affects who can be determined to be
right.
an owner and therefore have to get insurance.
And in this
it seems
particular,
to apply to those people who have a certain kind of authorization and use of the vehicle for a period, correct?
correct. But
So
the case,
why is permitted use, serially permitted use, the qualifier that limits somebody from being an owner?
I don't think it would be serially permitted use. That talks. I think
Well, that's what happened here, right?
Oh.
Your client was serially permitted to use the car.
I don't think so, because her husband testified at trial in his deposition that each time she wanted to use the motor vehicle, she had to
Right.
ask for specific permission,
Okay, so this is serially permitted use.
conditioned upon having to ask for permission each and every single
That's why I
time.
said permitted.
I'm not sure whether that's just semantics or,
I thought it wasn't, but maybe it is.
I don't know.
Well,
She
so
got permission a number of times in a series.
I'm sorry?
She got permission a number of different times
Yes.
in a series,
Yeah, it looks
Over
as though that
30
she was granted
over a
permissive
30-day
use.
period.
over 30 days,
It-
for
it-
more than 30
In
days.
total, yes, but not 30 days at one time. And there certainly were times where her husband said you could not use the motor vehicle, which doesn't comport with ownership of the motor vehicle if she could be, as Justice Bernstein was asking.
But it doesn't require ownership, it just requires having the use over a 30-day, over a period that is greater than 30 days.
Which comports with ownership of the motor vehicle.
Why
Well,
do
the-
you say that?
That's how the legislature defined ownership.
Pardon me?
The legislature told us what ownership means. It means having the use of a motor vehicle for a period that is greater than 30 days.
Isn't that exactly what happened here? Your client had the use of this motor vehicle for a period greater than 30 days.
If you cobble that all together on those.
What makes it,
on those
what
different
under the
occasions,
words
yes.
of this statute say it has to be 30 consecutive days?
Oh, I don't know that it does.
Okay, well, why can't you cobble them together, the entire use of the vehicle that was permitted?
Well, the husband certainly testified that his wife was given permission to use that motor vehicle, say on a weekly basis, but, I mean, there were occasions where he simply told her that she could not.
I understand that, but there was, I'm real literal, being very literally, didn't your client have the use of this motor vehicle for a period that is greater than 30 days?
In total, yes.
Then why doesn't the outcome need to be reversed here?
Need to be reversed? I don't think it should be reversed. I think it should be affirmed.
I know, but
Wha-
that's,
why?
okay.
You just said that, in fact, if you add up all of the times she had the use, it's more than 30 days.
That's the testimony, yes,
So then,
over a period of time.
So
That was the testimony.
if that's true, how do we rule for you?
I'm sorry?
What if we would like to rule for you? And you've just told us that your client, if you add up all the days, it's more than 30 days. So now, let's say.
That's in the record.
So I want to rule for you. how do I write that opinion? How can I rule for you?
Oh, I think you have to base it upon, the use did not comport with ownership. And that, there are a number of cases.
But the statute says you are an owner.
But there are
if you
cases
have the
interpreting that
use of a
statute.
motor-
All right, what are those
What we've
cases?
said, our court says it's the right to use the vehicle, and you don't dispute that for at least
Twitchell.
30 days, she had the right to use the vehicle, correct?
I don't
But
think
it
she had an
wasn't guaranteed.
unfettered right.
But she
which-
didn't have a guaranteed right to use the vehicle.
No,
had to
she did
seek
not.
permission,
There were-
and
she
isn't
did
it
not
fair
have
to
a
say it
guaranteed right.
It wasn't that she could rely on that use.
No.
It wasn't, and so she had to ask
Absolutely
for
not. She had to
permission,
ask for
correct?
permission each time.
My concern is, none of those words, permitted, titled, none of that is within the definition of what the legislature has told us an owner is. An owner is only those persons who have leased or rented, or who have the use for a period greater than 30 days. That's all that they say ownership is entitled to be.
But there are a number of cases that are interpreting the statute.
I understand that, but you know what? Those are all Court of Appeals opinions.
And there's a Michigan Supreme Court case that addresses that.
Okay, remind me which one that one
That's
is.
the Twitchell case.
And
Twitchell says she had the right to use the vehicle, but every time he said yes,
She had the right.
to use the vehicle.
She wasn't stealing it.
But she didn't have the right, nowhere in there.
No. It doesn't say, right to use is permitted, okay? But I don't understand why, if she has used it with permission, that isn't having the use.
Because the Twitchell case says that you have to have the right to use the vehicle, and she never had, no right had ever been conferred upon her.
Yes, but when the husband said, "You may use my car," she now has the right to use the car.
On that particular occasion, yes.
And if
for
we add
30
all those
days.
occasions up, we get to more than 30 days.
So why isn't she an owner?
Counsel, let me ask this question.
Well, if you look at that, the Twitchell case, it says exclusive use of that vehicle for a period greater than 30 days too.
Okay, so it has to be exclusive,
For a period of 30 days.
consecutive?
That's what I take for the Twitchell case, yes. Exclusive use, it means nobody else. Exclusive use means nobody else.
Why
And she did
isn't
not
it-
have that exclusive use.
But the paragraph 2 says consecutive days, and paragraph 1 doesn't say consecutive days. So why would I don't know how I get consecutive days in K1.
Well, you get consecutive dates by looking at the Twitchell case, where it references exclusive use, and her husband used that vehicle too. It was actually the only working vehicle in the home.
Well, so,
Her husband
So-
used it as well.
Counsel, who kept the keys?
He did. They were on his keychain. There was only one set of keys, and he had it.
why does that matter?
Why does that matter?
Yeah.
Well, if she had her own set of keys, that would suggest that she would have.
Good.
If she had her own set of keys, that would suggest that she really didn't have to ask him his permission to use it. She could just take it as she chose.
Counsel?
And that's not the case.
It is the case that in Twitchell, the arrangement was for a permanent transfer of the vehicle, that it would be exclusive. But
It hadn't been paid for yet.
I understand that. But you suggested that the holding of Twitchell, not the facts of Twitchell, were that the use had to be exclusive.
Yes.
I'd like you to point that out to me.
It's certainly in the head note.
Well,
I don't have the entire
I happen
text
to
of the
have
opinion in front of
opinion
me,
in
but I'm looking
and
at.
I don't see anything in the holding that suggests that exclusive use is required as a condition of being an owner. That's
Head
what I
note
was
2
asking you
suggests
to.
that.
Huh?
I don't have the entire opinion in front of me.
So let's just think about why that would be. Let's say that my husband and I only own one car, and I work days and he works nights, and our agreement is that we have one car, and I'll come home and I'll give the keys to him, and then he'll go to work, and then he comes home in the morning and we switch. That's the understanding that, now I don't have exclusive use of the car because my husband takes it to his night job. I'm not an owner. Every single day I drive the car to work, to my day job. I bring it home, I give the keys to my
Well, you're
husband.
probably joint owners at that point.
Not exclusive.
But it's not exclusive.
No.
I share the car with my, so exclusivity can't be the rule.
I guess you'd have to look at the arrangement between the husband, you and your husband.
So what arrangement could we have that would mean I was not an owner?
Exactly that. If it was the single car and he had the keys and you had to ask him every single time whether you could use the
So
motor
it's
vehicle.
permission, you think? Having to ask permission every time
Yes,
is what makes me not an owner.
right, because if you have to ask for permission, it means that you just can't take his keys and drive to the local Walmart to go shopping. If you have to ask him each time, yes.
So permission, we read into having the use of a motor vehicle.
Yes, I would read that.
Having the use of a motor
The Court of
vehicle
Appeals looked at that.
without permission.
But doesn't that just prove too much? I mean, assuming Justice Larson's example, her husband's a little bit of a, weirdo, and he makes her ask permission every single morning, even when he comes home. It's just the way he is. They share the car, but he wants her to say, "Dear, may I please go to
May I
work
please
now?"
go to work now?
In the car, but every day, over and over again, she drives that car. Doesn't permission get to be a little illusory? Like, isn't there a point where, as a matter of law, a court would say, "No way, in that arrangement, she had I'm not saying under your facts, I'm saying that permission is doing too much work here, given that it doesn't appear in the statute, in interpreting having the use. She clearly has the use, no matter what weird relationship she has
Well,
with
what
her
if the
husband."
weirdo said no one day?
What?
What if the weirdo said no one day?
And?
Said, no, you can't use it.
And?
Take a taxi to work.
I was asking you under my hypothetical. Every day he says yes, but it's just a little thing they do. He likes every day for her to ask.
Well, he could say no.
Okay, you're not playing along.
Does that require them to start from scratch? If one day it's no and the next day it's yes, do you go from 3 days to 6 days, or after one no, does it go back to 0 days? And what's the statutory authority for that?
In a perfect marriage?
No, come on.
We're actually playing with the words here, right? The words matter, right?
Right.
Okay.
Question is
Words
how you
do
get to
matter.
30 days.
If the husband made her ask every single day to use the motor vehicle, well, okay, if she's married,
29 days, he says yes, and then on day 30, he says
says
no.
no.
And then day 31, he
Day
says
31, he
yes.
says yes.
Day 30, he says no, take the bus. Take
Take the bus.
And?
And then are we back to 0?
Yes, according to the no-fault
That's
act, yes.
consecutive, you think 30 days means consecutive days then, right?
Yes,
Why?
because I think that's what Twitchell says. I think it says exclusive use.
But how do you
Well, it doesn't say
reconcile,
exclusive.
maybe
It doesn't.
Twitchell's wrong, because if that's what it means, because K2 says consecutive and K1 doesn't say consecutive.
I'm sorry, Your Honor.
So the statute in K2 refers to a period greater than 30 consecutive days. And in K1, it just says a period that is greater than 30 days. It doesn't say consecutive. So therefore, I would infer that they didn't mean consecutive in K1.
Well, that would be one take on it, yes.
Okay, thank you very much.
Might there be a different take if you were to consider the word period for a period that is greater than 30 days, being one interval of time?
Probably.
Except that it says period greater than 30 consecutive days.
Thank you very much. The case is submitted.
In any event, I would like for the court to deny the application for leave to appeal.
Thank you. People versus